Hello everyone. In this video, we will discuss the concept of act done by a person under compulsion in the Indian Penal Code. We will cover the following topics. What is compulsion? Section 94 of the IPC, exceptions of Section 94 of the IPC, case laws on compulsion in the IPC, and the conclusion. So let us start with understanding what is compulsion. Compulsion is a state of being forced to do something against one's will. It can be caused by physical force, threats of violence, or the fear of death or serious injury. Now let us see Section 94 of the IPC. Section 94 of the IPC states that whoever does anything that he is compelled to do by the immediate pressure of unlawful restraint within the meaning of Section 339 or of a threat of injury to his person or to the person of anyone in whom he believes in good faith to be interested is not guilty of any offence by reason of such act. This section means that if a person is forced to do something against their will, they will not be held liable for their actions. For example, a person is kidnapped and forced to commit a robbery. The person will not be held liable for robbery because they were forced to do it under compulsion. A person is threatened with violence if they do not sign a contract. The person signs the contract even though they do not want to. The person will be held liable for their actions because they consented to the threat. A person is forced to kill someone. The person will be held liable for murder even though they were forced to do it under compulsion. This is because murder is such a serious offense that it cannot be justified by any circumstances. Now, let us see the exceptions of Section 94 of the IPC. The first exception is if the person consented to the restraint or threat. In this case, the person will be held liable for the actions. For example, if a person is kidnapped and forced to rob a bank, but they agreed to the kidnapping in exchange for a share of the loot, they will be held liable for robbery. The second exception is if the person did something that was so dangerous or immoral that it cannot be justified by the circumstances. In this case, the person will also be held liable for their actions. For example, if a person is forced to kill someone, they will still be held liable for murder even if they were forced to do it under compulsion. Now let us see some case laws on compulsion in the IPC. There are a number of case laws on compulsion in the IPC. Here are a few examples. State of Maharashtra versus Mohanlal Hirabai Sona. In this case, the Supreme Court of India held that compulsion can be a defense to crime if the person was so compelled that they were not capable of forming the necessary mens rea. Mens rea is the mental state that is required for an offense to be committed. State of Orissa versus Debaraj Behera. In this case, the Supreme Court of India held that compulsion cannot be a defense to crime if the crime requires a specific intent or knowledge. This means that if the person knew what they were doing and intended to do it, they will be held liable for their actions, even if they were forced to do it under compulsion. State of Haryana versus Phul Singh. In this case, the Supreme Court of India held that the burden of proof in cases involving compulsion lies with the defense. This means that the defense must prove beyond a reasonable doubt that the defendant was forced to commit the crime under compulsion. Conclusion: the concept of act done by a person under IPC is a complex one. It is important to note that compulsion is not always a defense to crime. However, if a person can prove that they were forced to do something against their will, they may be able to avoid punishment. Thank you.